With regard to the apportionment, that's another bogus gaslighting argument that actually supports my position.
All right, page one then. Page one is A18-781255, Harris versus Del Casal.
Good morning, Your Honor. This is Attorney Al Needham for Defendant Del Casal.
Good morning, Your Honor. Kurt Harris for the plaintiffs.
Harris. Okay. This is a motion to retax costs. Counsel, go ahead.
Thank you. Yeah, Your Honor, this is was brought by Defendant Del Casal, and we saw the memorandum of costs, and in the memorandum of costs, which is a pretty small document, it just lists out all the items, and one of which was Doyle Law Group. It was an invoice. It was under Exhibit 9 of the memorandum, and that's the that obviously stood out as an attorney fee, and so I filed a motion to retax, focusing on that item, so that's my opinion is attorney's fee is not recognized or treated as a cost, and I don't think this item should be treated as a cost. It's an attorney fee. That's my position on that item. And I think Mr. Harris had an opposition saying, I'm the one who caused this cost. I created it. And if the judge may recall, there was an issue brought at the outset of trial about whether an attorney can also be, an advocate witness role. And the court, you said it doesn't apply in this case, and the trial went forward. But Kurt Harris nevertheless saying, I caused this, created this cost, and I think he's making some argument, therefore it should be treated as a cost. I disagree with that. And the invoice itself, under Exhibit 9, I actually looked at it closer yesterday, and it's under Exhibit 9 there, where even before trial, the invoice here says, Mr. Doyle says he's preparing for the direct examination of Mr. Harris. I mean, so this occurred before even the issue arose, so I find it, I'm concerned that Mr. Harris would make that argument to this court, and because it causes me to have to then file oppositions and point out these false statements, time and time again. So that's my position on this item here. The only other issues are, I did point out that it triggered an opposition. My motion triggered an opposition. It appears to me there's been no citation to any rule allowing costs. He cited the cost rule, which is just the definition of costs, and the attorney's fees rule, and Rule 68. So I pointed out that there's been no. Mr. Harris has not provided this court with any authority, in my estimation, to award costs in his opposition. And I pointed out in the reply. And if the court is inclined to award costs, there is an issue whether they should be apportioned, because there is more than one defendant here. There's 3 defendants. And that's it for me, Your Honor, on my motion.
Thank you. Mr. Harris, explain to me how Mr. Doyle's legal fees are deemed a cost under any statute, under 18.005, or even if you want to say you're a prevailing party, how does Mr. Doyle's legal fees become a cost? It's not like he was an expert witness. If he was an expert witness, it would be a different story.
Understood, Your Honor. I did cite those down because that was a cost to me at that point. I know that Mr. Needham indicates that an issue arose. No, Mr. Needham raised an issue that was homespun, and he essentially talking about some advocate witness rule that he totally doesn't understand, where attorneys can represent themselves at any time. So a lack of understanding of the rules is brought about the fact that I incurred this cost. Now, I understand what you're saying, Your Honor. I understand it's not provided under the rules, but I did list it there in my memorandum of cost because I did receive an invoice on it. With regard to all the other costs, there are no objections to their reasonableness or the timing or the filing. So we'd ask that the $6,991.81 be ordered at this time. With regard to the apportionment, that's another bogus gaslighting argument that actually supports my position. If you look at the case Abdullah that was cited by Mr. Needham, apparently he didn't read it or doesn't understand it. Because there it's
counsels without attacking each other. Let's deal with the facts and the law.
Okay. In that case, it specifically states, just like everyone who practices knows, where the claims are inextricably intertwined, the court has the discretion to not apportion the cost. That case was totally different, with two different defendants and two different causes of actions versus separate defendants. In this particular case, these parties were inextricably intertwined, and the claims were all based upon the same factual circumstances against multiple defendants. Your Honor has the discretion to make a determination of apportionment, but you also have the discretion in making a determination that apportionment is impracticable, given the fact that these cases were totally interwoven and there's no way to distinguish one from the other. My personal opinion is Mr. Del Casal caused it all, and he should be apportioned every bit of it. But beyond that, Your Honor, we'd ask that the amount be joint and severable in the $6,991.80. I'm not trying to raise anything outside of that. I also put Mr. Doyle's fees in my motion for attorney's fees that I haven't seen that's on, Your Honor. I know that I did file that, but I did not get a notice of hearing on that one yet. But quite clearly, we're entitled to these costs. They are justified. NRS 18005 provides for them, and as well as NRCP 68. So the argument that somehow I haven't cited any rules or any law, I have no idea what he's talking about, Your Honor. The law is very clear on this. I was the prevailing party, and as a result, I am entitled to those costs. And they were reasonable and necessarily incurred. They're supported by a memorandum of cost, and there's been no objection to them whatsoever, Your Honor.
Thank you, Mr. Harris. Mr. Needham, any reply?
Yes, Your Honor, thank you. I pointed out and the court may be aware of the fact that statutes which allow or even permit costs are in derogation of the common law, and therefore must be strictly construed. I just mentioned earlier that it appears to me in Mr. Harris's motion he did not cite any authority for this court to award costs, except for Rule 68, which is the offer of judgment rule. And I explain why the offer of judgment rule doesn't apply in this matter. So again, we have an issue whether Mr. Harris has even provided this court with authority to even award costs. I'll start with that. We've already argued about this item. I think Mr. Harris concedes that it should never been, Mr. Doyle's bill should never been put on the cost memorandum in the first place, but that seems to have been resolved. In regard to the prevailing party, Your Honor, it's not a very straightforward, sometimes, definition. It can get murky. When you got, in this case, we had 9 different causes of action. 9. I point out that the judgment against Mr. Del Casal indicates 1 cause of action was established by the plaintiff, that 1 out of 9. So
let me stop you there. Is that how the court evaluates it? If a plaintiff brings multiple causes of action or causes of action in the alternative, and the jury finds for them in 1 cause of action, are you saying, oh, you're 1 win and 8 losses? Or did you prevail on a cause of action that the plaintiff brought against your client?
The court seemed to provide, in this state, seemed that the court has discretion on that. And each case is different. I'm just pointing out that fact. And I think it is a fact, and I think it's something that the court should consider in who's the prevailing party here. Because when you have all these alternative theories, they do have an impact on a case, and they cause any defendant to incur extra energy and expense dealing with all these alternative cause of action. In regard to apportionment, it seems like, and I cite the case there, and Kurt Harris read it, I read it, it seems like the courts should make an effort. I think we all agree, and Mr. Harris seems to agree, that the court should consider whether a cost should be apportioned. My position is pretty simple. We got a judgment here that would contain separate awards against separate defendants. There is no joint liability on the judgment. Just to be consistent, for consistency's sake, I think we can't all of a sudden make a cost award joint liability. So I think my position is that in cases where there's multiple defendants, perhaps it's really simple just to equally apportion the awards, or an award among all the defendants, unless there's some reason otherwise. I mean, that's my position I pointed out. And that's it, Your Honor, for my response.
Thank you, counsel. In regards to this matter, counsel, the Doyle fees are hereby stricken out. They are not valid basis for a cost award. However, the remaining $6,991.80 is in fact valid. There's no basis to object to. The vast majority of them are basically fine fees and legal fees that are costs that were incurred in the litigation of this matter. I find that Mr. Harris did in fact prevail in this matter. I also agree with you, Mr. Needham, that his offer of judgment was improper because it not only claims for monetary damages, but it asks for an injunction which would make it invalid. But I'm granting Mr. Harris the fee or the cost of $6,991.80, and they are going to be jointly. The court could not figure out a way to rip them apart or apportion them amongst the defendants based upon the charges that were brought forth. Mr. Harris, go ahead and prepare that order, pass it by.
Yes, Your Honor. The last issue I had, Your Honor, or last question I had was on that. Should I renotice the motion for fees at this point, or?
Yeah, it didn't, for some reason, it didn't get on calendar, Mr. Harris. I don't know why. That's something a master calendar thing is, but get it refiled and I can hear it.
Okay, thank you, Your Honor.
Thank you, counsels.
Thank you.
Page 2 is A2183.